And the second example I want to give you is the plaintiff was working part-time as a direct support worker for community living. And at the time, her employer, Community Living, operated 19 group homes and was a Schedule I employer. The plaintiff worked part-time, and her normal shift was from 8 in the morning to 10 in the morning. On the particular day that, of course, he ends up having an accident, she started half an hour early, so she would have ended at 9:30. And as events would have it, the motor vehicle accident happened at 9:45, 15 minutes after the end of her shift. But the accident occurred in a car trip in her own car, in which she was driving a resident of the group home to a workshop that was located at another community living location. And this was an unusual activity for this worker, and the worker said that she was simply volunteering her services. Well, the accident occurs when her car is struck by a school bus on the way to this second employer's location. The school bus was owned by Laidlaw. Laidlaw is a Schedule I employer, and so when the plaintiff sues Laidlaw, Laidlaw brings an application or a declaration that a right of action is taken away. And the issue before the tribunal was whether the plaintiff was in the course of her employment at the time of the collision. Now, the tribunal heard evidence that usually this resident would have been sent in a taxi or transported in a community living van. And this was the first time the plaintiff had ever transported a resident. The evidence was that, however, that the plaintiff and the resident had bonded, and that in her off time, the plaintiff would sometimes take him on outings purely as a volunteer. Other evidence was presented that the van owned by Community Living had in fact arrived to pick up the resident to take him to the second location, but that the resident had asked the plaintiff to drive him so that he could listen to music on the way instead of being in the van. And the plaintiff agreed. So the bus company says, well, you can't sue us because you're in the course of your employment for a Schedule I employer, and we're a Schedule I employer. And the plaintiff said, no, she said, I'm a volunteer, and that's not unusual at all. The people who work at Community Living are all good-spirited folks, and this is the kind of thing we do. I was responding to a personal request by this resident, and I accepted it out of friendship, not out of work duty, and I was off duty at the time. The tribunal, in its decision, looked at the criteria of time, criteria of place, and the criteria of activity. They said, time-wise, that she was, at that time of day, expected to be doing something work-related. And the tribunal referred back to a number of cases in which they've said that people arriving early for work and preparing for work can be held to be in the course of their employment. They looked at the criteria of place. They said, this is something the employer could have asked her to do. And they looked at the scope of duties that was in the job description. Even though the employer had never asked her to do it before, it was one of the items that was in the job description for the support worker. The tribunal looked at the criteria of time, and they said, well, this is regularly during your work time, so even though you're off shift, it's close enough. They said that because the activity was work-related and the employer had accepted it at the time, that she was in the course of her employment, was not a volunteer, and that her right of action was taken away against the other Schedule I employer.